Yes, Mr. Jamil.
Lordship, item 9, the last item. In terms of your Lordship's order, the state has filed affidavit.
Okay, very
I
good.
would like to file
Yeah.
a short reply
Yeah.
for 2 weeks
So
time.
things are moving now. Item number 9. Heard Mr. C.T. Jamil, learned counsel for the learned senior advocate appearing for the petitioner. So Mr. Jamil submits that in terms of the directions passed by this court, the state has filed an affidavit in the matter. So he prays that he be granted
2 weeks time.
2 weeks time to file a response thereto on behalf of the petitioner. Prayer accepted. Registry to list this matter after 2 weeks on a date to be fixed by.
Like,
May I please, Lordship? My Lord, I beg to mention item number 5. My Lord, here I've received instruction, but I sought some clarification, my Lord, and I'm yet to receive. So can I allow me to-
With regard to that applicability of 2013 Act.
Yes, my Lord.
Yes, madam.
No objection.
Any objection? We should have serious objection. On the prayer of Mr. Common Advocate appearing for the respondents, state respondents, the matter stands adjourned. You want to file an affidavit?
No, yes, I sought some
But to
clarification.
enable
3
him,
weeks,
to
my-
facilitate completion of information by him, instructions by him. Also, prayer is not objected to by the was not objected to by the learned counsel for the petitioner. Registry to list this matter after
3 weeks, month.
3 weeks on a date to be fixed by.
Much obliged.
Yes.
Promotion item number 1.
Yes, we have fixed the other matter on
Not
Fifth.
have a very solid ground in this matter. Not here we have arguments, my lord. Not kindly the so-called notice, my lord. The so-called notice is itself is vague, my lord.
See, the show cause notice,
And reply,
Highlights.
even 8-page reply, they have answered in only 2 words, not satisfactory. My lord,
No, no.
direct judgment of the Kranti Associates and all, my lord.
I got it. The affidavit, the show cause notice
Yes, my lord.
brings on record a default which goes back from the date when the contract agreement was signed.
Yes, my lord. This so-called is of last year, my lord. There is a silence.
What we do is we make the interim prayer also returnable on,
My lord, may I request, allow me 2-3 arguments, my lord, allow me to make, my lord. If I am not able to make out my case, my lord, may reject it, my lord. But may kindly come to the so-called notice, my lord. I will straight away come to para 11, my lord, at page 163. Lord, so-called notice is given for the violation of clause 3.1, my lord. May I read, my lord? Why I am saying, my lord, so-called notice is vague, my lord. So-called notice is given for the different provision, my lord, and punishment is passed in different provision, my lord. There is an improvement by them, my lord.
okay, show me
Para
that.
11, Hence, the consultant has caused the breach of the following clauses of the ministry circular number so and so dated so and so. First, 1C, delay of the submission of improper MPR, improper review of methodology, temporary work, QA, plan, manual, OM, plan, manual, etc. So now they propose what they propose for declaration of non-performance, para 12. Now, Lord, may kindly see my reply, Lord. 18.5. My lord, this is of last year. Today, as on date, nothing exists, my lord. No allegation exists. I am working there, my lord. It is almost 2 years I have worked there, my lord. Please see answer 13, my lord. I have reverted each and every point, my lord. Annexure 13, page 164. Each and every allegation, my lord, para-wise I have given, my lord. And now kindly see the finding in the interim order, my lord. Just 2 words, my lord. In reply to my 8-page, my lord, they have given only 2 words not satisfactory. No reasoning given, no explanation.
That is at page 88.
Page 88, my lord. I will straight away, my lord, come to the operative part, my lord. Para 16, my lord. Now the punishment order is passed under clause 3.3. Clause 3, subclause 3. And the so-called notice is for clause 3, subclause 1. There is no mention of 3 clause subclause 3 in the so-called notice. Para 16, my lord, page 94, my lord. Whereas the authority engineer has caused the breach of clause 3, subclause 3 of the aforesaid ministry circular dated so and so by misinterpreting.
You can come to para 15.
15, yes, my lord. Whereas the authority engineer has caused a breach of the following clauses of the ministry, dated so and so, clause 3, subclause 1C. This is what they have given in the so called also. And now the addition what they have done in 16. 16, whatever they are saying, it is not.
Just take me to the circular. It's
Yes,
on the
sir.
record.
May I read just one second? I can read this, Lord, page 94, Lord.
Hmm.
Lord, these are the para 16, Lord, whereas the authority engineer has caused the breach of clause 3, subclause 3 of the aforesaid ministry circular dated so and so by misinterpreting so and so, so and so. Whereas the default, what are the default, Lord? Non-mobilization of the key professional. There is no punishment for this, Lord. Only punishment is of financial implication that they have already done.
They have deducted your amount.
Yeah, they have, kindly see 12.5 contract. I have worked for 24 months. I have received only 12 lakhs, Lord. How do I deploy a person, Lord, expert, Lord, without money? That also letter is also on record. So first 4, Lord, there is no provision in the contract.
Just take me to that
Yes, Lord.
clause.
Circular of clause 710, Lord. Annexure 22. Page number 202, Lord.
Relevant.
Yes, Lord. Relevant is Lord page 203, third, which is in table, Lord. So they give me a so-called notice for violation of subclause 3, 1. And more particularly, my lord, they have said C. Delays in submission of improper MPRS, improper review methodology, temporary works, QA, plan, manual, so and so. And what is the my lord, punishment proposed? Last column, my lord, against the form. For first 3 instances to be kept on the watch list. My lord, there is no letter on record that they have not given me any letter in this regard, my lord. Thereafter, a monetary penalty of 1%. This is also not given, my lord. 1% of the consultancy fee of the aggregate of such penalties in a contract would not exceed the performance guarantee amount, and or declaring the consultant as a non-performer up to 6 months, or till the rectification, whichever is earlier.
Now
And
they
what-
have put it later.
And they have given me permanent punishment, my lord.
But Mr. When was this order passed?
My lord, this is improved order.
11. And you are still continuing there.
I am continuing. They are not terminating. I requested them to forego my contract because no person is going to go there, my lord. Because of the, my lord, the condition of the weather and that there is no connectivity. No.
Heard Mr. Rajiv R. Raj, learned. Rajiv R. Raj,
Please, Lord.
learned counsel for the petitioner, issued notice, returnable.
They have not dealt with my reply, but just one word, my lord, not satisfied.
Issue notice. The present petition has been instituted. The present petition has been instituted by the petitioner company, inter alia, assailing the note or assailing the communication dated 11/11/2025, by which the petitioner company has been declared to be a non-performer for a period of 2 years or till the rectification of deficiency, whichever is later. The learned counsel for the petitioner has taken this court through the show cause notice issued in the matter and has submitted that the penalty imposed is on grounds beyond that was highlighted in the impugned show cause notice. In the show cause notice, the learned counsel for the petitioner further submits that in pursuance to being engaged as the consultant, authority engineer, as the consultant for the consultant for the authority engineer, in spite of issuance of the said communication dated 11/11/2020, impugned communication dated 11/11/2025, the petitioner herein is continuing with the said assignment till date.
Yes, my lord. After 30 months, 24 months, we have already done.
You are continuing till
Yes,
date. Till date. Also, he submits that the circular violation of which has been alleged against the petitioner petitioner company in the show cause notice, and basing on which the penalty has now been imposed, provides for a penalty other than the one now imposed upon the petitioner. Also, there is no representation on behalf of the respondent.
Lord, I saw them yesterday physically.
I said nobody is here.
Yes.
Respondent number 1, the employer, the employer. Also, in view of the said submissions made by the Learner Council for the petition, and also on perusal of the show cause notice as well as the impugned order dated 11/11/2025, this court is of the considered view that the same would mandate to be kept in abeyance till the next returnable date. Also, accordingly, the impugned order dated 11/11/2025 shall remain suspended till the next returnable date. Full stop. Registry to list this matter again on 5/12/2025.
Just but now what they are doing, they are applying this punishment order retrospectively, and the bids which we have submitted 6 months ago now being declared by retrospective.
That is not under challenge here. That you have your independent challenge. We will not do that. Till 5/12/2025. Full stop. The petitioner, the Learner Council for the petitioner shall bring this order to the notice of the respondent number 1, the authorities of the respondent number 1, with a further by requiring respondent number 1. The respondent number 1 shall be permitted to make its submissions in the matter on the next returnable date. The further continuation of the interim order would be considered on the next returnable date after hearing the Learned Council for the respondent number 1.
For admission, item number 2.
But yesterday that you did not have knowledge.
No, Lord, I have
This is this is beyond.
I'm also talking beyond, Lord. If I would have given some time, Lord, I would have, Lord, made out my case, Lord. This was also one of the ground, Lord, there also.
Okay, fine. Let's see.
Lordship, I'm appearing on behalf of my senior. She is indisposed, so kindly let this matter come up to.
Prayer is made on behalf of
Nitya Kosa Council for.
N. Koza, Learned Council for the respondent number 6 on the ground for an adjournment in the matter on the ground that the Learned Council is presently indisposed. Prayer is not objected to by the Learned Council for the petition. Registry to list this matter again
To vacation, your lordship.
after the ensuing winter vacations on a date to be fixed by.
Obligation, your lordship.
For admission, item number 3.
Yeah, please,
Any instruction, ma'am?
Your Lordship, here my colleague is appearing. She's indisposed, but however, she's informed me that she has sent a affidavit for vetting. So
No, only thing which I would like to know is whether there was an inquiry.
Your Lordship, here the matter is not handled by my colleague,
Okay,
so
okay,
I'm not aware of the facts. Your Lordship.
No inquiry
Yes,
wherein you participated.
there has been a proceeding, but then the allegation, our case is that no opportunity was given to them, to my petition.
That's a different thing altogether. Whether there was an inquiry,
There was an inquiry.
you
that's what-
participated.
Yes, my lord, I just have a humble submission before this honorable court. That since from the last 2 occasions, they've been saying the same prayer.
You
So
must have
I-
heard what madam has said. Her colleague, she's having some problem.
Yes,
And this is a case of termination, a dismissal.
yes,
So there can be no interim direction here.
my lord,
You get back, we interfere with this, you get back everything.
my lord, since the
Why have you not, if you are getting technical, I'll also get technical. Why did you not file an appeal against this?
My lord, we have submitted the representation and the petitioner was not in a position, he was languishing in jail.
Mr. Langkumer,
Yes.
wait. If the projection you have made in the petition
Yes,
is substantiated from the records, this order will not survive. this impugn order will not survive.
Yes.
And if we interfere with it, you get back everything.
It might just for subsistence of the petitioner. He's facing a criminal trial on the other hand, and he has a family to feed, Lordship. Just on that point, Lordship, if they can take time to file the affidavit, but then if the dismissal order is stayed by this honorable court, the suspension order will still subsist. But then at least 50% of the salary.
See,
and other
that is the
losses-
problem. That is the problem. If I have to stay your dismissal order,
Yes, my lord.
I better quash it. I cannot stay. Because by staying it, I reinstate you in service, which would be contrary to the penalty imposed. Right. The materials only will give madam an opportunity. Before the vacations, we'll have the matter.
Yes.
Let the affidavit be filed, and if this contention of yours is substantiated, this matter need not be detained. It can be considered. But from the records, if we find that you were given all opportunity,
Yes.
then you are in trouble.
No opportunity was given. Even written statement was not allowed to submit.
Mr. Lamkumer, I have come across much.
Yes.
Basing on the statements of the clients, we make big statements in the records.
Yes.
Moment the original record is produced, we find it recorded therein, cross-examination denied. That's the end of the matter. Ms. Leonard, your additional advocate.
No, Your Lordship, I'm government advocate.
Government advocate submits that appearing on behalf of Ms.
AINE.
Learned government advocate submits that the affidavit in the matter has already been prepared and would be filed within
a week's time.
within a week's time. For so. Registry to list this matter again on 9/12/2025 for so. Along with the affidavit that has now been undertaken to be filed by the respondents. Full stop. Next day, that comes up, you can always say.
Another point, just want to have an inquiry for this honorable court. With regard to representation during the pendency of this case, the department has replied to it. So whether that can be.
You can
by
bring
way
up,
of an
file an additional
Yes.
affidavit that, because that is, if it is rejected,
Yes.
it does not substantially mar your
Yes.
challenge.
But just want to bring it on record.
File an affidavit. The petitioner is at liberty to bring on further pleadings before the next date of listing. Petitioner is also granted liberty to bring on record further pleadings if so advised. Yes, Mr.
Service where dusty and because Monday holiday so bad was taken out of reach.
আমি কেনেকৈ কৈছো এইটো steps কথা কোৱা নাই নেকি? Learned petitioner to take service to effect service of notice upon the respondent number 1 and 2 by way of dusty was routed through the registry of this court. So on filing of the on effecting such service, an affidavit be filed in the matter. Yes.
For admission, item number 4.
Please, Your Lordship, a similar prayer on behalf of my colleague, Your Lordship.
Similar prayer.
Yes, after a week.
Affidavit is ready. Namgita khali loilo ba. Just give the names. Huh?
Yes.
2 consuls, madam sir. Same thing.
Yes, Your Lordship, same prayer. Much obliged.
Yes.
For admission, item number 6.
Your Lordship, here, same on behalf of my colleague, but here she is yet to receive instructions. So
A prayer is made on behalf by Ms. Learned government advocate for an adjournment in the matter to facilitate filing of the affidavit by the respondents. Also, prayer is not objected to by the Learned Council for the petitioner. Registry to list this matter after 2 weeks on a date to be fixed by. File it. Landowner.
For admission, item number 7.
Yes. What happened to the affidavit?
Online, my lord, in
Okay.
this matter.
What happened to
Your
your
Lordship, in
affidavit?
this matter, Your Lordship, I'm yet to receive instructions, Your Lordship.
That's been going on.
Your Lordship,
Last occasion, my lord, they took time for filing counter.
no, Your Lordship.
You
here-
have a interim protection, Mr. Counsel.
No, my lord, I don't have any interim protection in this. And it is not a case of interim protection, my lord, because monies have to be paid by the state.
It's not this. Sorry, I got it
Your
wrong.
Lordship, I also like to bring on record, Your Lordship, but the service copy was given to me only almost after a month, Your Lordship. So that's the difficulty there.
The
And
same pleading was made last occasion, my lord.
but
How
and
much
in
time would
between
you-
there
how much time?
3 weeks, Your Lordship, to file.
We'll have
to
it
get-
immediately after the ensuing vacations. File your affidavit in the meantime. We'll have it immediately on reopening of the vacations. Let them file their affidavit in the matter.
I have no idea about the vacations at Kohima, my lord.
Going on till, when is it opening?
14.
on-
15, we'll have it immediately thereafter.
15th December, my lord?
No, January. It will be from December to January here.
If I may, on 16, Your Lordship, because 15 I have personal.
We'll have it on 19th. Mr. 19th, will it be?
Problem. Yes, ma'am. Make it final, my lord, by that time, saying that they should be
Miss so-and-so learned
final
government.
opportunity.
Yeah, Inahali.
Yes, Your Lordship.
Inahali learned government advocate. Miss Inahali learned government advocate submits that the affidavit on behalf of the respondents represented by her would be brought on record invariably on or before. When give me a date.
I'll make an interview.
Huh?
19, on 19, right?
No, we are having the case on 19th. So when can you file it?
I'll make an endeavor to file before that, but
No endeavor filing
I can't give a date, Your Lordship.
on or before 15/1/2025. Full stop. Registry to list this matter again on. We'll have it on 22nd, 22/1/2025. Full stop. In the event the affidavit is not in a position to be filed, comma, the Illinois government advocate shall furnish before this court the stand of the respondents received in writing from a competent authority by covering all the issues raised in the present writ petition. You give us a stand in writing, we'll consider if the affidavit is not filed.
Lordship.
Obliged, ma'am.
For admission, item number 8.
Here the interim order is there.
Here also my colleague, she's handling this matter and she's in this post. So she's informed me that she's yet to receive instructions in this matter.
Miss
So-
Inoli, learned government advocate, appearing in the matter, prays that she be granted further
2 weeks.
3 weeks' time to bring on record the stand of the respondents by way of filing an affidavit. Prayer is not objected to by the learned counsel for the petitioner. Registry to list this matter after 3
Your
weeks
Lord-
on a date
Your
to be
Lordship.
fixed by it. Next, interim order passed wide order dated 7/10/2025 shall continue till the next returnable date. This interim order I had applied in the earlier case.
From the supplementary cost list for admission, item numbers 10 to 14.
Mr. Longkumer,
Yes.
we have yesterday dictated, but there is some more aspects to be brought in.
Yes, my lord.
This order, I'll upload it on Monday or Tuesday from Gauhati. What we have done is we have rejected your prayer for regularization by saying that there is no challenge to the policy of the government here, 29/4 and 22/9 and 17/3/2015. I'm not gone beyond that. With regard to your prayer for parity, we have allowed that. And we have also made a provision that you will be released that amount from a date 3 years prior to the date of filing of the writ petition, following Tarsemsing. Right?
Yes.
Disposed of. But you will get the order only on Monday or latest by Tuesday. Okay? You can apply for that and you will get it.
Or if the, with regard to framing of policy, if that can be of that often.
I did not go in because state already has a policy. Rightly, wrongly, you present a challenge to that. I'll add a line. It will be open to you to challenge that. I'll add a line.
Just on a submit, this submission. Then if in that case, since there is an existing policy, whether the petitioner can also be.
I have said that you are covered by that policy and you will be considered, but you don't have a scale. So there may be a aberration there. So you can make your challenge to that effect. Get my point? I've said that you are. The state having already formulated a scheme for regularization of services of work charge of casual employees in the state. This court finds that the same would also stand attracted to the cases of the petitioners in the above noted writ petition. The petitioners have not challenged. They said so and so, and accordingly, the policy of the state reflected in the said office memorandums, not being under challenge, it would not be permissible for this court to proceed to direct the respondent authorities to prepare a fresh scheme for regularization of the services of the temporary ordinary grade warders, including the petitioners here. But the way you submitted that bonus is that I've made it applicable from 3 years prior. Thank you. Merry Christmas to all. And really thanks for the cooperation. Thank you.
Merry Christmas to you all. 내가 50kg lagi, ayah satu tinggal 20 kan lah. Bila ni cukup tu lagi sampai saja. Ayo.